Good morning, everyone, and welcome to today's webinar. Today's topic is residential evictions and will be presented by Ashley Hawkins. Before we get started, I would like to take a moment to go over a few housekeeping items. My name is Hallie Schossler, and I will be the webinar organizer for today. We want to make sure today's presentation is extremely valuable for you, so we ask that you submit all questions by clicking on the question button in the control panel and typing your question. Your questions are only visible to me, and I will collect and submit all questions to Ashley, who will answer them throughout the presentation. We will have additional time at the end for any further questions. A little bit about Ashley. She is an attorney who practices consumer collections, primarily focused on collateral recovery out of Weltman's Cleveland office. She is a member of the Cleveland Metropolitan Bar Association and the Ohio State Bar Association, as well as a certified guardian ad litem for the Cuyahoga County Juvenile Court. Without further ado, I will now hand it over to Ashley.
Good morning, everybody. First of all, I would like to say thank you for tuning in. Everybody here at Weltman and myself, we do appreciate it. I hope that everyone is staying safe out there. One other thing that I would like to say before we get started is my allergies are kind of rough right now. I don't know if I even had allergies before I moved to Cleveland, but they're fine until they're not. So if I need to take a water break, I'm ready to go, or if I need to clear my throat, please just bear with me. I am okay. It is not COVID, I promise. It is just Cleveland allergies. So in any event, let's go ahead and get started. First of all, I would just like to also share some housekeeping details. Please make sure to mute your phone. If we get some background noise, something going on where you are, it might throw everybody off, so just please make sure that you're muted. If you have any questions, be sure to type them in. I would really appreciate questions as you have them. I certainly will take questions at the end as well, but you might forget them, or someone else might be thinking of the same thing that you are when you have that question, so I certainly don't mind being interrupted to answer. I don't think that we'll make it all the way to 12. I'd like to get you guys out of here with a few minutes before you head to lunch. So that is our timeline for today. All right, what will be covered? So I'm going to talk a little bit about what Weltman does, what I do here, and then we're just going to head right into eviction. So there are two main parts today. So Eviction 101, just some background information for people who may not be too familiar with the process or really what eviction is. And then we're going to get into the CARES Act and kind of a little bit about the eviction moratorium that's going on right now. Again, I know that some listeners may not know anything about this. Some listeners may be 100% caught up, but we will just try to go over some of the details so everybody's on the same page. All right, so Weltman, this is where I work. We are a nationally recognized full-service creditors' rights firm, so we represent creditors in a few different areas. Those main areas are real estate default matters, bankruptcy, consumer and commercial collections, and commercial litigation. So as Hallie said, I am mostly consumer collections and evictions. So we follow all the compliance and security standards that we're supposed to. If you want to know a little bit more about us, go ahead and head over to our website. It's pretty helpful and it looks pretty good. All right, so let's get into it. Part one, let's talk about some evictions. So forcible entry and detainer actions. That sounds kind of complicated. Also, it's a lot of legal jargon. What that means, it's really just evictions. So I'm probably not going to say forcible entry and detainer actions. It's also a handful, and I would probably mess up the words the more times that I say it. So we're just going to stick with evictions. So a landlord can bring an eviction action under the Ohio Revised Code, Chapter 1923, for possession of the premises. So what gives the landlord the right to come in and take back possession of their premises? So there are a few things that can get them there. So the most common one that I would have to say probably 99% of people out there think of when they think of eviction is for default of rent. So that's when someone doesn't turn in their rent, it's late, something that has to do with their rental payment not getting to the landlord for the premises. So there are a few other things that are not as common as default of rent payment. However, you may not have heard of them, or maybe you know a little bit about them. So second, violation of or failure to comply with applicable building, housing, or health or safety codes. I always like to think of this one. It's easy to remember, and it's a good example that covers a few different bases here. So I have been watching the show Hoarders with some of my time at home during this quarantine. I like to think of a hoarder situation as something that certainly would violate a housing, building, health, or safety code, probably all of those actually. So maybe just keep in mind the TV show Hoarders. If you've ever seen it, definitely some premium TV. So moving on, we have a holdover of a lease term. So that's somebody that stays past their agreed lease term. So if you're supposed to be out on July 1st, if you're still hanging out, you didn't tell your landlord that you wanted to stay any longer past July 1st, technically you're a holdover tenant. And then lastly, we kind of get into something that's a little bit more complicated, probably not that prominent. However, I'm sure that it is certainly out there. So the premises would be located within 1,000 feet of a school premises when the tenant or other occupant in the premises appears on a sex offender registry or they've been convicted of or pled guilty to a sexually oriented offense. So that's pretty explanatory. I'm not going to get too far into that, but those are the 4 reasons why a tenant can evict, why a landlord can evict a tenant. So what happens when we have a tenant that falls into one of the categories that we just discussed? So upon termination of the rental agreement, basically any property or money held by the landlord as a security deposit would be applied to the payment of any past due rent or if there are damages to the property that the landlord has suffered. So in reading this bit, I don't know if I've ever worked on a case where a tenant gave property to the landlord to hold as a security deposit. I'm sure that it's happened out there somewhere. However, most of the circumstances that I'm familiar with have to do with just money being held as a security deposit. So any damages suffered by a landlord can be pursuant to the terms of the lease agreement, so very specific pieces of that agreement, or the tenant's noncompliance under Ohio Revised Code 532105, which lays out a lot of the tenant's obligations. So a good example of one of those obligations under 532105 is using and operating all electrical and plumbing fixtures properly. This seems pretty obvious, although I wouldn't put it past some tenant out there to do something wild and this be the reason that they get evicted. So I have a few other sections under 532105. However, I don't want to put too much text on these slides for you guys. Although I do like to provide the ORC section in case you want to go reference it for yourself. Although this is kind of interesting, so that I'll just go over a few other pieces of this specific section as to what would be a violation. So if you're not keeping the premises safe and sanitary, you're not taking your trash out or disposing of it in a clean way. Let's see here. We talked about the hoarder situation. You got to comply with all the health and safety codes. And then, of course, we actually get into something a little bit different that people may not think of. So under this section, you can be evicted if you unreasonably withhold consent for the landlord to enter the dwelling. So this isn't for any old reason. It can be for the landlord to inspect the premises, to make any sort of agreed repairs, alterations, improvements to the property. This falls under the appropriate umbrella for the landlord to come in. They want to keep up their property for the next tenant after you. So you need to be a little bit reasonable with letting them in, or it could get you evicted. So if there's a tenant out there that violates any provision of this section that we've been talking about for the past couple of minutes, the landlord may recover any actual damages that result from the violation together with reasonable attorney's fees. So what that means is the cost of the damages to the property plus what it costs for that landlord to hire an attorney to handle it. That's not too hard to grasp. It all makes sense when you really take a couple of minutes to think it over. But are there any questions that I can take right now in relation to this portion of the presentation?
We don't have any questions yet.
Okay, perfect. Thanks, Hallie. All right, and just a reminder, please feel free to stop me. You just type those questions in. Hallie will let me know that there's a question, and we can take them as they come. All right, so let's move on a little bit here. Okay, so what other basics out there about eviction should I be aware of? So I like to think that probably everybody on this phone call has rented at some point in their life. So some of these things may start to ring a bell, although perhaps it has been a little bit of time since you've had to deal with it. So any deduction from the security deposit, the landlord has to itemize it and identify it in a written notice that gets sent to the tenant. So that notice will contain the amount due, and it needs to be provided within 30 days after termination of the rental agreement and when the tenant receives delivery of the property back, so delivery of possession. If the tenant doesn't provide the landlord with their new address in writing, the tenant kind of becomes limited if there's a legal action set forth in what they can recover damage-wise. So they would not be entitled to damages or attorney's fees if they didn't provide this information to the landlord, because how are they supposed to send you your money back if they can't find you? So then we get down to if the landlord fails to comply with sending you an itemization of the security deposit or the funds used to fix whatever damages, that good stuff. I remember when I was in law school, I'm pretty sure that my roommate and I got dinged from after we moved out of our place. We didn't sweep up some leaves or something, so they will itemize that and send all of it out. And of course, if they need to make any repairs or pick up after you, they're going to charge you for it. So in any event, if the landlord fails to comply with this, what the tenant can recover is property and money due to them. So like I said, usually people aren't handing over property for a security deposit, they're just handing over money. So with those damages in an amount equal to the amount wrongfully held and reasonable attorney's fees. So that amount coming back to them will certainly vary dependent upon how much is held and what's going on there, but that is what happens if the landlord fails to comply with getting you your security deposit back. All right, so now let's get into Eviction Process 101. I have found that I myself learn better when I break things down into steps, and I hope that that goes for many of you as well. So we've hit the background details. You kind of have an idea about what goes into an eviction. So let's talk about legally what we're working with. So I think of things, at least this portion, in three parts. So we have the pre-legal action, which is everything that happens before the filing of the complaint. We have the first cause and then the second cause. So first cause is a hearing. It is to ask the court for an eviction if the tenant is still in the premises. Then what we get after the first cause hearing a few weeks later is the second cause hearing, which is asking the court for the money damages. So we will get into the details of each of these steps as we move along here. All right, so pre-legal action. Like I said, pre-legal is pretty self-explanatory, but it really just means before I or an attorney here at Weltman would draft and file a complaint with the proper court in the jurisdiction where the tenant lives. So what would basically happen is the landlord would advise the property owner of non-payment or other violation of tenant. So normally what we see is that a property owner, maybe they don't live in town anymore and they want to hire a company or a rental company, somebody to manage the rental and leasing of their property while they're not around. So the property owner might not know if a tenant did not pay rent on time. So what we would see here is the landlord would go ahead and be in contact with the property owner, advise them of the non-payment or violation of the tenant, and see how they would like to proceed. So if the property owner gives the go-ahead to evict the tenant, the first step that is taken is called a 3-day notice. So the landlord would post a 3-day notice at the property. Something that I really would like to draw attention to, you can see it here in red font. No rent or other payments may be accepted after the posting of this 3-day notice. So why? I mean, that seems like a pretty harsh cutoff. What if somebody was 1 day late? What if something was going on? If the landlord and property owner really want to move forward with evicting this tenant, maybe they've had some trouble with them in the past, why they would not want to accept payment is because if they do accept a rental payment that's late, what they would need to do is then you're kind of tied in for another month. Is you have to wait a whole other month and say, oh man, are we going to have to do this again next month? Is the rent going to be late next month, and we're going to have to do this all over? So I would say if the 3-day notice gets posted, it should just be a hard cutoff. You're not taking any payments after that gets posted. So the 3-day notice, what do we need to have on it for it to be valid? There are a few things here, and as we go through them, they're pretty obvious, but you want to make sure that you include everything that is necessary, or perhaps the 3-day notice will not be appropriate. So we have the date the notice was served, name and address, Why is is it late rent? Is it a violation of the lease? Is it a violation of the Ohio Revised Code? Why is the 3-day notice being posted? However, there are a couple of other things as well. So, got to say that the tenant has 3 days to move out and should specify exactly what move-out date the 3 days falls on. A certificate of service specifying how the notice was given. So basically what this means is 3-day notice can be served in a variety of ways. It can be served by certified mail, which is where you send it and the person has to sign once they receive it, and then we get notice that the person signed, so they become served. You can drop it off in person, or you can leave it in a conspicuous place at the rental premises. So usually we see these notices getting taped to the front door, I would say is probably the best and most obvious place. Then there's typically a statement that needs to be included. It really just kind of lays out exactly what's going on. It's listed there on the PowerPoint. And sometimes this specific statement needs to be formatted in a certain way. So maybe it needs to be in a certain type of font size. Maybe it needs to be bold, italicized. You just want to make sure that you're looking at your local jurisdiction where this is going to be happening. The eviction action will be happening, to make sure that you're following all of the appropriate rules, because you don't want something to get thrown out because you forgot to include something on a 3-day notice. So, all right, let's move it along. All right, a little bit more about... Oh, I'm sorry, go ahead.
Okay, we have 2 questions for you. The first one is, can a lien holder request entry to the premises?
So a lien holder requests entry to the premises. I would say I've never had a circumstance where that has happened. However, I would say it's probably not appropriate at this stage of things to ask. Is there any details that can be provided that may help me understand that question a little bit better?
No, unfortunately, that's it.
Okay. So I would say probably not at this point in time. However, there may be a circumstance where down the road that may be appropriate. Whoever submitted that question, if you would like to email it to me, I would be more than happy to do a little bit of research, or perhaps you could provide some background information for me so that way I can look into it and get you the right information. So I would suggest that at this point in time, but I'd be more than happy to look into that. So, Hallie, you said there's a second question, right?
Yes. The second question is, this attendee has searched for years for the answer to how much he can charge for his labor to repair damages, a price that would be both fair to him and the tenant.
Okay. I'm not quite sure what the appropriate amount to charge for work done, maybe in repairing damages that fall outside of normal wear and tear. I know that I am currently working on a matter through Cuyahoga County Common Pleas Court where I have a property owner who did all of the repairs to a property himself along with his wife or girlfriend or significant other. I do not recall how much they charged their time per hour. I don't think that it was normal, like hourly wage right now, like minimum wage. It may have been a little bit more than that, but that person who maybe asked that question, email me and I'll take a look at their spreadsheet and see how they did it. I don't know if they followed anything specifically, but they definitely billed their hours in a certain way, and that is what I included with my complaint to the court. So why doesn't that person send me a quick email, and I will definitely take a look at it after this presentation. We can go from there. All right.
Perfect, and then be caught up.
Okay, great. Thanks, Hallie. Okay, so pre-legal action continued. So this is after the 3-day notice has been posted, then what happens? So then the landlord would provide to Weltman the lease tenant ledger, which is really just an itemization of all of the rental payments that the tenant has submitted, and then it's kind of like a joint list of what the landlord then, if there's a missed rental payment, how much it is, when it was, or any other late charges or fees that have been added to the list after perhaps the tenant has stopped paying. So that is what a tenant ledger is. It's actually very helpful, and I always look for that as the second thing behind the lease. So we have the 3-day notice that we need as well, and then of course any lease addendums or renewals that may have been filled out during the tenancy. Sometimes people have other documentation as well that they submit. I sometimes see rental registrations that get shot my way. That's always good to have on hand if you have an updated rental registration. And then sometimes people just send other items that they think would be helpful for me to look at. So there's not really a hard cutoff on what you should send, but this list here is at least the required documentation that I would need when I take a look at a matter like this. So once I receive all that documentation and I take a look at it, I begin to draft an eviction complaint. So like I said previously, that eviction complaint gets filed in the proper jurisdiction where the tenant's address is. So I do a lot of things in Cleveland Municipal Court and some in Cuyahoga County Common Pleas Court. And then of course there are surrounding cities and courts as well that we visit every so often, but that's usually where a lot of my cases are located. So as I said, the complaint typically contains two parts. Sometimes it can contain one part, but we'll get to that here in a moment. So we have the first cause, which is the eviction portion. You're asking the court to get the tenant out of the property because they haven't paid or there's been a violation. The second cause is you're asking for the rent that wasn't paid or what the amount was to go through and fix damages, that sort of thing. So as I said, if the tenant has already moved out of the property pursuant to the 3-day notice, sometimes we don't need a first cause, because if they're already out of the property, then we don't really have anybody to evict. We just want the money. So it's kind of like a choose your own adventure. I have to look at each situation. Sometimes tenants stick around after the 3-day. Maybe they don't have anywhere to go, or maybe they're still trying to work out what's going to happen with their living situation. But if they're already out, there's no need to have everybody show up at court for a hearing that is unnecessary. So if we don't have to go for the first cause, I can usually just get it dismissed by motion, and then we just wait for the second cause to roll around. So what happens with the first cause eviction hearing if it does go forward? So if the person is still in the premises, the hearing needs to happen. Sometimes the tenant will appear for the hearing. Most of the time they do not. I honestly can't say that I've ever had a first cause hearing that has lasted more than like 10 minutes. I think that that's probably saying on the longer side. Sometimes the tenants come in and it can last a little bit longer, but if they do not appear, it's a really quick in and out hearing because the court probably has 30 other hearings of this nature that day. So what happens is I show up at court. The owner, landlord, or the agent of either, whoever is going to testify to the information about the property needs to show up. So through testimony, we basically advise the court of the important and pertinent facts needed to get the tenant out of the premises for non-payment or violation. So what I do on my end is I prepare what is called a first cause eviction script. So this gets sent to whoever is going to appear with me for this hearing, so that way, excuse me, they know exactly what I'm going to ask them. It's not a surprise. It is not something that they should really stress out about. I give them the questions. I know the answers, so I put the answer there. And then if there's any discrepancy with my answers, of course, we talk about it and get the right information on the script. So if the eviction gets granted, the court then issues what is called a writ, which is really just a formal order. They schedule the eviction if needed, and then set a move-out date that is provided to the tenant. So usually this move-out date, a lot of tenants get out before then. So it's kind of unnecessary. It's really just to keep them on track. And then if they're still in the premises after that move-out date, that is when the bailiff from the court shows up for the formal eviction to really just get them out of the property. So if the tenant moves out, like I said, first cause can be dismissed by motion. It, is not worth the court's time or anyone else's time to show up for a hearing that we don't need. So if they're out, the landlord or the property owner just lets me know, and I can just get that dismissal together and file it, and we can be done with that portion. So are there any questions about the first cause eviction? The next slide will talk about the script a little bit more. If anybody has questions about that, we can always hold.
No questions.
Okay, awesome. Let's move on. Okay, so this is so I changed some of the information. An example of a first cause eviction script. So the biggest question that landlords or agents, whoever shows up with me to the hearing, is, oh my gosh, I'm really nervous to be a witness. This is I have to be in front of a judge or a magistrate, and then there's going to be people seated in the courtroom. Like, are you sure that you want to do this? So it is not that bad, I promise. This is the basics. This is the information that the court's going to need if they need to grant the eviction portion of this complaint. So it really just goes over some of the information that we've discussed previously. I hate to say it, as much as we want it to be like Legally Blonde or A Few Good Men, those are some of my favorite legal movies. It's not going to be like Elle Woods interviewing Chutney on the stand about the perm. It's not going to be that big speech at the end of A Few Good Men. I can't even remember the exact quote, like, you can't handle the truth or whatever. I promise it's not going to be like that. It is very quick. It's relatively quiet because you're just up really, really close to the magistrate or judge, and you get through it pretty quickly. So I ask the questions, the person that's with me answers. It is unfortunately not as dramatic nor anywhere near as interesting as either of the movies that I just discussed. So nothing to be worried about, I promise. Okay, so second cause. This is the part that, really piques everyone's interest because they want to be made whole from the funds that they are out because of this tenant. So the second cause hearing, we're just proving the money damages associated with the property. The owner, landlord, or agent, whomever is the best set to provide testimony, would prepare a total amount of damages incurred. And they show up again. We get to hang out again in court, and we provide this testimony to the court for the second cause hearing. So what the landlord or property manager prepare is similar to the tenant ledger that I discussed a couple slides ago. So it really just lays out all of the costs associated with the property, rent, late fees, here we go, allergies, the late fees, everything, so the court can appropriately look at what is due from the tenant in regard to this property. So I prepare a second cause script, an eviction packet, which is really just a copy of the tenant ledger that I provide to the court. So what are these money damages? What can they be? So we're talking non-paid rent. If the landlord is paying utilities under the rent and then charging the tenant, there could be non-paid utilities that are due under the lease. And then, of course, any damage to the property outside of normal wear and tear. And then, of course, court costs for filing the eviction action. So if the second cause gets granted, this is really what everyone gets happy about because it means that we have a judgment that we can now execute against the tenant. So the landlord and property manager can start collecting the money that they're out. So an order is issued by the court stating that a money judgment has been found against the tenant or tenants, and then this is the amount that we collect on at Weltman through our post-judgment efforts. So are there any questions about the second cause hearing or anything like that? The script looks a lot like the first one. It's just a little bit more tailored to the cost.
We don't have any questions yet. Oh, wait, we just got one.
All right.
The question is, if the tenant moves out and leaves items behind, how long do I have to wait to enter the property? And also, how long do I have to hold on to the property before I can discard it? This would be a non-eviction situation. We had a tenant move out without notice, couldn't get a hold of them, but they left behind.
Okay. So if it was a non-eviction situation and the person has just left, I would say, so because the security deposit and tallying of all of their costs are due within 30 days, I would say you would probably be safe to hold it, that you wouldn't need to hold it past 30 days. But then again, I would use your discretion. If it is something of value, well, I hope that they wouldn't leave something like very personal to them behind. But if it is just trash, I would say it's probably, you might have to have somebody come in and haul it out, or you might have to spend someone's time in cleaning up this property that was left behind. And that may be something that could get deducted from the security deposit. So I would say not longer than 30 days because you may have to then figure out the cost of handling those items to then send, if any, of the security deposit back to that tenant if you can find them, if they didn't provide an address. So that would be my answer. Is there a follow-up to that or anything?
Nope, that's it.
Okay, thank you, Hallie.
Uh-huh.
All right, so let's let us move on to what happens if you get this judgment. All right, great. You have jumped through all of the hoops. Maybe you had a first cause, maybe you didn't, but you had a second cause, you have a judgment, fireworks go off, very exciting. So we specialize in collecting on judgments against debtors. When I have heard through the grapevine and kind of seen as I go to court myself that many other firms stop after they obtain a judgment. So they might not do anything post-judgment, and you may be thinking, oh no, who am I supposed to go with if I have this judgment and my current attorney or whomever is handling it can't collect on it for me? So a lot of those people actually pass the collection portion to us, or maybe elsewhere, but a lot of them come to us. So if you want a firm that handles everything in one place, you don't have to jump around and talk to or do research on a bunch of different places. We handle it from pre-legal action through post-judgment collections. We can keep it all in one place, under one roof. So there are a few different types of post-judgment collection methods. And there are some like strange peripheral ones that we don't see too much, but the three that I have listed here are the main ones that we work with here at Weltman. So we have wage garnishment, a lot of people have heard of that, bank account attachment, which perhaps people have not heard of, and then property attachment, which also wage garnishment is like the star here. I feel like that's all that anyone ever has questions about or asks about. So that's definitely the most common one I would say that we do here. Post-judgment, though, can be a little bit flexible. So if somebody, like a tenant or a debtor, comes forward and says, hey, I'm sorry that I didn't participate in all of the court hearings. Maybe there was a family member that was sick, maybe something was going on and they couldn't participate, but they say, hey, I have a good job, or I have the ability to pay every month on this. Like, is there a way that we could avoid post-judgment collection efforts if I just set up a payment plan? And then, of course, if that person does not follow through on their payment plan, you are still able to pursue post-judgment collections. So sometimes that happens. I would say every so often, people don't want to get garnished, or people don't want the money taken right out of their bank account. So sometimes when they see that there's a judgment, they come out of the woodwork, which is always nice because you get to have a conversation with them about their situation. So let's start with wage garnishment. This is a lot of text. I know that it is. I'm sorry. A lot of the post-judgment collection stuff can get pretty heavy. So I have included the ORC section if you would like to do any additional research on your own. I know that reading a statute is also can be a little bit much sometimes. So I have included kind of the basics on the slide, at least if you need somewhere to look back if you have a question. So what is wage garnishment? It's really just a person who obtains a judgment against another person. You can garnish the personal earnings of that person. So that's kind of a mouthful also. So basically, it's someone who has a judgment and you want to collect on the judgment and they have a good job. So you take a certain amount of their earnings from that job, and that's how you begin to get the judgment paid. That's kind of the normal person version of wage garnishment. So prior to filing the actual garnishment, the creditor, so us, must mail the debtor, the person being garnished, a demand for payment to avoid garnishment. This is really just an opportunity for them to set up a payment plan with us to avoid the garnishment. Then the debtor has 15 days to complete a form called a Note C, and they have to return it to us with a calculated payment to avoid the garnishment. If they do not return this form, that is our go-ahead to file an affidavit and an order of garnishment with the court, and then the court takes it from there. So the garnishment of personal earnings is continuous until we file for it to stop, and a creditor is only entitled to 25% of a debtor's net income pursuant to wage garnishment processes. So this also, we're going to get to some exemptions a little bit further in the presentation, but some funds are exempt. So a lot of government benefits like Social Security payments or workers' comp, those cannot be garnished for a good reason, because you want somebody to still be able to live and accept the government benefits that they're entitled to. So we'll get to that here in a few slides, do not worry. So wage garnishment does kind of fall under a couple of other things like tax levies and child or spousal support. So if you kind of find yourself in a situation like that, it's good to kind of come to us and ask how these things work, because there may be other things going on that could be higher priority than a garnishment. You want to make sure that you know kind of exactly what you're working with. All right, so let's move on to the next form of post-judgment unless there are any questions. All right, I'm not hearing it. What's that, Hallie? All right, I'm going to continue unless Hallie lets me know that there's a question. I think there may have been a text thing right there. All right, so let's move on to bank account attachment. So the language that I've included here makes bank account attachment sound a lot like wage garnishment. I think bank account attachment is a little bit easier to remember than if we were to say garnishment, because then you're dealing with wage garnishment and then bank garnishment, and it can get kind of dicey. So a person who obtains judgment against another person may garnish, attach, to the debtor's property other than personal earnings. So we're talking about bank accounts mostly here. So if the property is in possession of a person other than the person against who we have a judgment, so the bank, because they have an account with the bank. So once the garnishment is filed, the court serves the garnishee, which is the bank, with an order. So basically what the bank does when we want to attach to somebody's bank account, they have to answer to the court whether there are funds, because there is a cutoff, which I promise we'll get to in the exemptions. And if they do not fall under the exempt amount, they have to pay those funds to the court. So after the bank answers, the debtor has a short window to request a hearing and argue that the garnishment funds are exempt. I have been to a couple of these. The main thing that happens is that the debtor wants to come in and argue things that happened in the previous case. So we're not there to argue any facts about how we got here. We are only there to discuss whether or not the garnishment funds are exempt, and it's the debtor's, burden to prove that they are. So I remember one time I showed up for a hearing like this, and it was a mother who was getting garnished, who was having her bank account attached, and she was handling the fund, the finances of her son who had been in an accident. And I believe that he had some brain damage. So she was handling his rent, his bills, his medical expenses, all of that stuff because he was unable to. So in that case, there was a true question of, are the funds that were taken out of her account exempt because she was handling her son's matters? And that's always the question. You can't really argue anything else except we really have to stick to whether or not the garnishment funds are exempt. So that's the main problem, but it's usually not a problem because typically the funds are not exempt. So no notice is required to the debtor, and if they don't request the hearing, the request is waived. Unlike wage garnishment, which is continuous, bank attachments are a one-time event. So if there's enough money in the account above the amount that is exempt, you attach one time, you're good to go. All right, so let's get through bank attachment. Hallie, stop me if there are any questions.
Will do.
Thank you. All right, so let's move on to property attachment. So I know on the original slide that explains post-judgment collections, the only thing that I listed was a lien. I'm also going to talk about levies very briefly. We see a lot of judgment liens more than levies. So I would say maybe focus a little bit more on that because levies just are not really as prominent in what I've seen here. So a property attachment to real property is called a judgment lien. So that's the ORC code if you want to look into it a little bit further than what I've included. So a creditor can place a judgment lien upon real property owned by the debtor. So to attach this lien, what a creditor does is they file the certificate of judgment, which is really just a certified copy of the judgment from the court. So they stamp it, they say that it's, true and correct, and then they send it over to a clerk at the common pleas court in any Ohio county where the debtor owns real property. So my family lives in Stark County. I work in Cuyahoga County. Let's just say for argument's sake, I own a house in Stark County and a house in Cuyahoga County. So if somebody had a judgment lien against me, they would then file in both Stark and Cuyahoga. So that's just one thing that you want to kind of keep in mind if you are ever going forward with the judgment lien process. So the clerk then dockets it and indexes it in a judgment docket under both the creditor's and debtor's names so it can be found. A judgment lien does have a time limit on it, so it will remain attached to the debtor's property for 5 years. So that's a pretty long time. I'd say that that's a pretty good time frame that we're working with here. So one thing, though, to keep in mind is that in Ohio, a judgment does become dormant after 5 years, after the date of judgment or last execution. So after 5 years, you may not have a judgment lien anymore, which could be frightening. And we don't ever want to get to that point. So once the judgment becomes dormant, you can file for what is, that wasn't the right way to say that. So when the judgment becomes dormant, you can file to make it alive again, which is really just called a motion to revive the judgment lien. So that needs to be brought within 10 years after the judgment lien became dormant. So 5 years, that it's good. As long as you bring the motion for revival within 10 years, you should be good to go. So as a practical matter, judgment may be enforceable for a minimum of 15 years if the proper steps are taken to revive the dormant judgment. So you just don't want to let it go too far, and you do want to be very cognizant of some of the timeframes that you're working with here, because nothing would be worse than to see that you've missed something by a small increment, especially when you're working with years. So that is a real property judgment lien. A lot of what we do is for post-judgment collections, we may do a wage garnishment and then also file a judgment lien. So these things can be done together. It's not one or the other. You don't have to choose, but dependent upon what is going on with the debtor, that may limit your choices. So that is judgment liens. And I will now move on to the last bit here about property attachment. All right, so this is what I just said. A property attachment on personal property is called a levy. I don't see this too much. I don't know if I've ever covered anything where we have had to make it to the point where we needed to do a levy. So this kind of gives the creditor a few different options with the debtor's assets as they can be seized and sold to satisfy the outstanding judgment. There are some procedural requirements in ORC, the 232909 through 14, that really kind of explain what needs to happen here. So the statute requires a creditor to issue a writ of execution. As I said, that's really just a formal order, and that would direct the sheriff to go ahead and seize property. The creditor, however, though, this is kind of where things, maybe somebody wouldn't want to pursue this route, is the creditor, so us, the person that we represent, may incur costs to ship and store the property. So I would say a good example maybe here would maybe be a car or a house. I mean, you can't really store a house, but there could definitely be some larger costs that are incurred if one chose to pursue this option. So pursuant to ORC 232915, the creditor is then also obligated, in addition to the costs that we just discussed, to bear the expense of the court's appointment of 3 independent appraisers to figure out the value of the property. So that way, everything is done fairly. No one is pulling the wool over anyone's eyes about what the property is worth. So following that appraisal and some other notices that go out as well, the creditor must then auction the property and may not sell it for any less than 2/3 of the appraised value. This process, as I'm sure that you can tell just going through these details, can be time consuming, and it can really rack up a bill. So it would really be up to our client and if they would want to take on the costs of pursuing a levy. There's also really no certainty that anyone's going to show up to bid on this piece of property anyway. So you're really just running into a lot of uncertainty, and one thing I found is that I myself do not like uncertainty, and a lot of other people don't as well, especially when it comes to money. So this is maybe not the best option for people that like certainty. Then there's kind of another way to get this property. I've never seen it happen. It's called, we would file what is called a motion to turn over property. So it's really just an order that the property of the debtor that is not exempt, we're going to get to exemptions next, not exempt to be applied towards the satisfaction of the judgment. This there's a couple things that have to happen before you can do this motion. This can only be done after properly conducting a debtor's exam. So a debtor's exam, kind of like a deposition, maybe a little bit more casual. It is where I would sit down with the debtor and kind of get a sense of, are they working? Are they taking care of family members? What kind of other debts do they have floating around out there? Really just get a sense of their financial situation to see if it would be worth it to pursue anything that they had discussed with me. And a debtor's exam is done under oath, so they would need to be honest with me. They can't hold anything back. What happens with the motion to turn over property is it gets in front of a judge, and a lot of judges would be uncomfortable issuing such an order, and I completely understand that, because you're filing a motion to take somebody's property. And some judges, maybe they might not be on board with that. I haven't seen it. It's, who knows how successful it would be, dependent upon the judge that you're in front of and also dependent upon the jurisdiction that you're in. But that is also something that could be available as a post-judgment collection effort on Weltman's part. So, are there any questions? That is really heavy. I completely recognize that. It's tough, but if there are questions, definitely shoot them my way. If you need a little bit of time to digest this, I can certainly take questions by email or by phone at a later time. Like I said, I completely understand that this is some heavy stuff.
Looks like there aren't any questions at the moment.
Okay, thanks, Hallie. All right, so let's talk about exemptions really quickly. So, exemptions to executing on a judgment. Got the Ohio Revised Code sections there. I'm just going to talk about some really popular ones where people have questions usually. So $125,000 in real property where the debtor lives, $3,225 in a car, $400 in cash on hand. So that is the limit for a bank account attachment. If somebody has less than $400 in their bank account, we can't attach to it because those funds are exempt. And then $500 in any particular item, or $10,775 in household items. And then lastly, we did already talk about some government benefit payments like unemployment or disability. I think that I previously stated Social Security or workers' comp, because if people are entitled to certain government benefits, we should not be able to attach to them. They should certainly be exempt. And one thing that some people do not understand is 75% of a debtor's net earnings are exempt. So it's all well and good that someone has a judgment, but that person still needs to be able to live. They still need somewhere to stay. They still need to get around if they have a car that is exempt. They still need money to feed their family. So 25% of the earnings are not exempt, 75% are. So that's kind of the magic number that we want to keep in mind with that sort of thing. So I said before, if a post-judgment collection kind of payment plan can be established between the creditor and the debtor, that's fine. I think that that's wonderful. Sometimes it's a little bit easier to move forward in that way. If not, any of these options can be pursued. One note that I do want to make, I have a lot of clients who will call me and say, hey, I saw that you just filed the complaint, thumbs up, when can we do a wage garnishment? Like, did you start yet? And sometimes I have to remind them that you cannot pursue a wage garnishment until you have a judgment. So many of these matters can sometimes last a few months in court. There are service requirements that we have to meet. There are certain hearings that we have to appear for. And you cannot pursue a wage garnishment until a judgment is issued by the court, and then we can execute on that. So I think sometimes people get a little bit confused by the order of events. So I'm hoping that maybe if anybody is listening or watching this PowerPoint today, that this might clear some things up so they kind of understand the timeline a little bit better. On another note, post-judgment collections can be a little bit slow. Wage garnishment is continuous, and if somebody has a good job, that means that they're getting paid every 2 weeks. So a little bit of money will be taken out of that check every 2 weeks. It's slow going, but eventually the judgment will get paid and the creditor will be pleased. So it can be a little bit slow. It is definitely nice to have some patience. Patience is a virtue, especially in law. So sometimes we just need to have that to get to the end of the tunnel. All right, so I just have a quick summary page unless there are any questions. Like I said, I like to break things down. It's easier for me to understand if things are in pieces and a little bit more summarized than if I'm just reading a statute that's full of legal jargon. So we have the pre-legal action. That's when we do the 3-day notice. Landlord provides, all of the requested documents to Weltman. Then we get it, and I draft and then file. Although once we file, it is, we're now in the legal realm. We're not pre-legal anymore. First cause, second cause. Sometimes we don't need the first cause, but the second cause always stands. First cause, you show up with me. I prepare the script. We provide some testimony to the court. And then the second cause is then set a few weeks later. We appear again, provide some testimony to the court. And then if the second cause is granted, there's a judgment issued by the court. Then once you have that judgment in hand, we can start to pursue some post-judgment collection efforts. So wage garnishment, bank account attachment, property attachment. But if some payment plan can be arranged instead of pursuing one of those methods, sometimes that's better for everybody. All right, let's talk a little bit about the CARES Act. So I'm thinking some people that have tuned in today have maybe read the piece that I put together for our website about the FAQ for the CARES Act eviction moratorium. This is going to reiterate some of the information. I'm also going to emphasize some of the information, so just bear with me if you've already read that. So what is the CARES Act? It's the Coronavirus Aid, Relief, and Economic Security Act. So my goal is to make this digestible for normal people. Legal jargon is hard to read, and I've said that a few times. So I want this to be as takeaway friendly as possible. So if there are any questions on terms, definitely stop me, but I've tried to simplify it in an understandable way as much as I could. All right, so there's a piece of the act that kind of talks about what sort of tenants will be covered under this act. So we have covered dwellings and then covered properties. What we are working with when it comes to a covered dwelling is a dwelling occupied by a tenant pursuant to a residential lease, or without a lease, or with a lease terminable under state law, and is also on or in a covered property. So that's wordy. It's hard to understand. We're going to break it down a little bit further here in a sec. So then we have covered properties. What's a covered property? So it's one that participates in a covered housing program or a voucher program. And then when we talk about mortgages, it's a federally backed mortgage or a federally backed multifamily mortgage loan. That's tough. If you want an exclusive list when it comes to the federally assisted housing programs and federally backed mortgage loans, I would definitely take a look at our website. I have provided a link there if you would like to give it a click. Of course, you don't have to do that right now. You can stick with me till the end if you want. Okay, so that chart, it looked fancy, but what does it mean? So for a tenant to fall under the CARES Act eviction moratorium, what is a landlord looking for? A residential tenant occupying a dwelling with or without a lease and is also in or on a covered property. So remember what that covered property is. It's a property that participates in a covered housing program, voucher program, or has a federally backed mortgage. I have had some clients approach me in the past couple of weeks about this. Many tenants will not be covered under the CARES Act. That's just kind of the reality of the situation. But the tenants that are covered under the CARES Act are a very specific bunch. And I'm hoping that this slide specifically will really, really help narrow down if someone truly is covered by the CARES Act or not. All right, so what does the CARES Act mean for landlords? What can landlords do right now? So it really restricts the ability to evict a residential tenant for non-payment of rent. Only non-payment, not violation. Some of the other violations that we discussed could still get somebody evicted. This is only talking about non-payment right now, if that tenant falls under the scope that we just discussed. So landlords also can't charge fees, penalties, or other charges related to the non-payment of rent. So that's pretty self-explanatory. The rent didn't come, you can't charge them a late fee if they qualify under the CARES Act. They can't issue a notice to vacate until after the moratorium ends, and they cannot require the tenant to vacate until 30 days after. Excuse me. the tenant is provided with said notice to vacate. So then on the flip side of that, what does it mean for residential tenants that qualify under the CARES Act? It means that your non-payment is not going to get you immediately evicted during this moratorium. Rent due is not waived or forgiven during this time. I've seen a lot of talk online. People think that like because there's a moratorium and like maybe they're not employed right now, that they don't respect their landlord and they're not going to pay, and it's just too bad. They're still on the line for all these rent payments that are due. It's just if they, it's not waived or forgiven unless you have made an explicit arrangement with your landlord. I don't know if landlords are making explicit agreements or arrangements like this, but I'm sure that there's somebody out there that has done this. Tenants can still be evicted during the moratorium, as I said, for other violations that we discussed under the Ohio Revised Code at the beginning of the presentation, except the non-payment of rent. That is very important. So eviction of non-payment can still be pursued at the end of the moratorium. The landlords just have to wait it out. All right, so when is this moratorium going to end? I've had a lot of people ask about this too. So the period of the moratorium, it started on March 27th. It is supposed to run for 120 days. So I put the date in Google to make sure that I got 120 days on the dot. It is July 25th, 2020. That is when this moratorium is to end. So once this time frame expires, landlords can issue a 30-day notice to vacate to residential tenants that fall under the CARES Act for non-payment. So this notice is different than the 3-day notice that we talked about earlier. So it has to provide 30 days for the tenant to vacate. That is very clear under the Act. So 30 days, not 3-day. That is the main difference here. All right, so some people have said, like, is there something that doesn't fall under the moratorium? Like, I've heard people still have evictions in court right now that are going on. So, as with most things, and as I was told in law school, almost as a joke, in probably every single class that I took, there are always exceptions. And then everybody sighs and moans and groans, and you just have to learn the exceptions. So, eviction matters filed before March 27th, 2020 may still be pending in court. So basically what that means is if somebody filed an eviction on March 26th, it's good to go. It's probably still pending, and that is completely fine under the CARES Act. So those involving non-covered tenancies. So these are things that don't fall under the covered dwelling, covered property distinction. And what that could mean is transient lodging at a hotel or a motel. I have a couple of other examples, like housing for seasonal agricultural employees. And this is a very specific one that may be helpful to people as well. So those involving non-covered tenancies would be renters of space in a mobile home park. However, renters of a mobile home and space may be covered. So that would be an interesting thing to look into if that's something that, as a landlord or as a tenant, is specific to you. Or we have evictions based on reasons that fall outside of non-payment of rent, fees, or other charges. So like our hoarders example from earlier as well. That good show on TLC or A&E or whatever it is. One note I would like to make about exceptions is just because there is a tenant right now who may be ripe for eviction that does not qualify for protection under the CARES Act, it does not mean that the jurisdiction or court where the eviction would be filed is currently accepting new eviction filings. I think here, if I remember correctly, I think Cleveland Municipal Court is picking back up on eviction filings on June 15th, although my understanding is that it's not. I don't know if they're accepting brand new eviction filings or if they're just trying to handle what was on the back burner during all of this and try to get those caught up. I'm thinking that the new eviction filings are definitely stayed a little bit. I think the June 15th is specifically for things that were already hanging out in court before all this happened. So I would suggest always check your local court's rules before filing anything. It might just save you some time and some effort. Some courts are accepting filings and they'll just hold them. Some courts will reject the filing. I would say just be a little bit up to date and check court orders before you move forward with anything, because a lot of courts are stayed right now on eviction filings altogether. All right, so what happens if you're a landlord and you have a tenant, that falls under the CARES Act? You know, what are you supposed to do? You don't want to violate the CARES Act, but you want to make sure that you're covered and that your livelihood is safe. So the landlord should not serve a 3-day notice to vacate for non-payment. Remember, because we're under the moratorium, we have to do that 30-day. So instead, the 30-day notice should be issued after the expiration of the moratorium. So after July 25th, 2020. If the tenant has not vacated after the 30-day period of the notice, then it would be appropriate to issue the 3-day notice instead. So under the moratorium, we're doing a 30-day and then a 3-day if they're still hanging out. That is probably, for argument's sake, if you have a tenant, you do the 30-day, they're still not out, you do the 3-day, they're still not out. We're probably talking about the end of August 2020 right now as to when it would be proper to file the eviction complaint. So I would just keep that in mind. I know that that is a long time away. I know that the moratorium is kind of scary for everybody, but just try to keep some of these timeframes in mind because they do end up being very important to compliance with the CARES Act. So as far as I know, the eviction procedures after the 3-day have not changed. That does not mean that they won't change or that a specific court may call for some flexibility. But right now, this is what we know for sure, although things may, start to change as we get a little bit farther into the moratorium and then also after the moratorium. Okay, so that wasn't too bad, right? Or at least I hope not. Again, I apologize about my allergies. I know that I sound super silly. But in any event, please feel free to contact me. If there are any questions, I can certainly take them now. That is my email. That is not going to change. However, my phone number will likely change. As some people know, I am transferring to our Columbus office at the end of June. So I would say if you're not sure what my new email is, you can call me, what my new phone number is. Definitely give me a call at this number and I can let you know. Or it's safe to just shoot me an email because I don't think that's going anywhere. So is there anything that I can help with? Anything else that I can provide clarification on? If not, shoot me an email. Give me a call, come visit, maybe once the quarantine is over. We are in Brooklyn Heights, and I would love to get some visitors. That would be wonderful.
Thank you, Ashley. It doesn't look like we have any additional questions coming in at the moment, but we'll give the attendees a second to submit any. While they do that, I wanted to mention that if you're interested in any of our most recent webinars, we do have a complimentary recording stage that will be included in the follow-up email later today. And additionally, we will be announcing our next webinar later this week, so be sure to visit our website for that announcement too. Looks like we just got a question. It was just a thank you, so you're welcome, and thank you, Ashley.
That's very kind. Thank you all for attending. Stay safe out there. We will get through it, I promise.
I think that's it for today. Thanks, everyone, for joining us.